Sir, at Department of Corrections, can you tell me your name, please? Can you tell me your name, please, there at the Department of Corrections?
English.
Mr. English, okay. Mr. Horowitz, were you ready on Mr. English's matter? We'll call People versus Michael James English, two files, file number 244923 and 4925. The record should reflect Mr. English is present today by video from Michigan Department of Corrections. If I could have counsel put your appearances on.
Michael Horowitz on behalf of Mr. English.
Okay, this is set today for a motion hearing. Mr. English filed a motion to have these files dismissed based on a violation of the 180 day response. Mr. Horowitz, anything that you wanted to say by way of
Forever, such that they end up not getting credit on their new pending cases. Thank you.
Thank you, Mr. Saber.
Your Honor, I would largely rely on my written motion and the cases cited therein, just strictly for the notion that the 180-day rule does not require the trial to commence within 180 days. It only requires the prosecution to take some action to begin moving towards trial within 180 days. These cases were both charged before the defendant was even incarcerated in DOC. So there is no technical violation of the 180-day rule. I would rely on it.
All right. Anything in response, Mr. Horowitz?
No, Your Honor, thank you.
Okay. Again, I did have a chance to review the written submissions by the parties. The oral arguments here today on the record are consistent with the arguments put forth in the written motions. I also had a chance to review the case law applying to the 180-day rule. First of all, the court would point to People versus Hendershot, 357, Mich 300, case going all the way back to 1959, interpreting the statute and the 180-day rule consistent with what prosecutors articulated, which is the rule does not require that the trial be commenced within 180 days, but that the prosecution make efforts on the case during that 180 period, and that the prosecution promptly prepares the case for trial. Any delays in the 180-day period will be charged against the party that's responsible for the delay. But again, case law is clear that as long as the prosecution makes good faith efforts to proceed promptly with pretrial proceedings, get the case ready, and eventually do trial, there can be no violation of the 180-day rule. In this case, the court notes a couple relevant facts. First of all, as the prosecutor indicated, these cases were charged before Mr. English's current incarceration, which involves conduct subsequent. Second, there have been some delays. However, several of those delays were due to the Michigan Department of Corrections. The court would point to some of the more recent rulings, including People versus Witkowski, regarding the COVID pandemic, where the Supreme Court has ruled that those types of delays are not attributable to the prosecution. So the court finds that those delays could not be held against the prosecution. The court would also point to Mr. English's own conduct here in court, in which the court found him guilty of direct contempt for his behavior during one of the proceedings, in order that he be held in jail for 90 days on contempt. That is a delay that's clearly attributable to Mr. English and his own actions. So the delays that have occurred are not attributable to the prosecution and would not go towards the 180-day period. But even if they were, again, I agree with the prosecutor that I don't think it's applicable in this case, given the order of the charges and Mr. English's current incarceration, or order in time. And the court finds that the prosecution has proceeded diligently with attempting to bring this case to trial. And again, the trial is not required to occur within 180 days. So for all those reasons, the court is going to deny the motion. Mr. Horowitz, the court would request that you prepare an order that reflects the ruling of the court and submit that either under the 7-day rule or with the stipulation as to the form.
Your Honor, would it be acceptable for the motion to state the reason stated on the record?
Yes.
Then I want to file a motion to have him removed from bench for being biased.
I'm sorry, could you repeat that? I couldn't hear you.
I want a motion filed to have him removed from my bench.
Okay, you're free to file that motion.
Judge. I want to file for biasness against me from you because you are being biased. You're siding with the prosecutor on bullshit.
Okay, you're free to file.
And I will take this to the Supreme Court too.
You're free to file that motion at any time you would like to, Mr. English, and I will rule on it accordingly. Okay, so for the record, Mr. English has voluntarily terminated his participation in this hearing by hanging up on his end. So I just want to make the record of that. Mr. Horowitz, anything else we need to address today?
No, Your Honor, thank you.
Mr. Ziegler.
There you go.
Thank you. Okay, Mr. Fragel, were you ready with your case?
Yes, Your Honor.
We'll go on the record in People versus Brian Crawford, file number 55036.
Or Your Honor, Patrick Fragel, we have Mr. Crawford.
Record should reflect Mr. Crawford's present here in court today. Mr. Fragel, how did you want to proceed in this case?
The defendant intends to accept the offer to plead guilty to count 1, drunk driving, third offense, IBAC, with the understanding that if he completes 12 months of probation, the case would be reduced to drunk driving, second offense. There's no objection to prosecution at the 30-day mandatory.
About this agreement.
Yes, sir.
Solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
I do.
Mr. Crawford, are you currently on any kind of probation or parole?
No, sir.
And you understand that if you were to unsuccessfully complete the delay in this case, that the maximum possible penalty you can face for the charge, which is operating the IBAC as a third offense, would be up to 5 years and or a $5,000 fine.
I do.
With that in mind, what is your plea charge?
I plead guilty to it.
So I'm going to go through your rights with you. I know you signed an advice of rights form. I'm sure Mr. Craig do that here on the record as well. You have the right to have a trial. You have the right to be tried by a jury. You have the right to be found innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you if you're at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf if you're at trial. You have the right to remain silent during a trial and to not have that silence used against you. And the right to testify at a trial yourself if you want to. You understand all of those rights.
I do.
And you understand that you're going to be giving up and waiving all of those rights by pleading guilty.
Yes, Your Honor.
Also, you don't have an automatic right to appeal the plea that you're making here today. The only way that you can appeal it is by leave, and that means that you would have to ask for the next higher court up to Court of Appeals to hear your case. If they said no, that would be the end of any appeal. You understand that?
I do.
Has anyone threatened you with anything to get you to plead guilty?
No, sir.
Has anyone promised you anything other than what was said here on the record?
No, sir.
Is it your own free choice to enter this plea?
It is.
Are you pleading guilty because you are in fact guilty?
I am.
This incident happened back on October 2nd of 2024. Is that the correct date? On that date, what was it? Alcohol.
I was.
The alcohol, did you operate a vehicle on US 131 here in Cussing?
I did.
And at the time that you were operating that vehicle, was your ability to safely and normally operate that vehicle impaired because you had consumed alcohol?
It was.
Did you have any blood or breath tests to determine the level of alcohol in your system?
I did.
Do you remember what that result was?
I read it today. It was a 0.197 breath or blood and like a 0.10 breath.
Okay. Do you have any reason to doubt the accuracy of those tests?
I'm not gonna say I do.
Okay. Had you previously been convicted of operating while intoxicated back in 2001 in the 77th District Court
I was.
and in 2006 in the 13th Circuit Court?
Yes, sir.
Mr. Ziegler, are the people satisfied with the factual basis?
Yes, sir.
Mr. Fragel?
Yes, Your Honor.
Mr. Ziegler, are the people satisfied, or I'm sorry, are the people aware of any threats, promises, or inducements other than what's been placed on the record?
There we go.
Mr. Fragel?
No, Your Honor.
And Mr. Ziegler, are the people satisfied that the court has complied with statute? The court will take of this plea?
Yes, sir.
Mr. Fragel?
Yes, Your Honor.
Mr. Crawford, the court finds that your plea is knowing, voluntary, and accurate. The court is satisfied that there is a factual basis to support a finding that you are guilty of this charge. The court will accept your guilty plea. We'll set this matter for a sentencing hearing. You'll be notified of the date and time of that hearing. It's important that you stay in touch with Mr. Fragel prior to that, and you're going to meet with Agent Vera here briefly today to set up a pre-sentence interview. Mr. Ziegler, anything else you need to address on this case today?
No, sir.
Mr. Fragel?
Just a quick request on bond, Your Honor. The defendant has been submitting the daily preliminary breath test since October. I believe he started them voluntarily. I started them on my own. He's now taking some medication that causes him to sleep in a little bit. So we'd ask if that daily PBT could be moved to the afternoon hours, so he doesn't miss any in the morning.
Any objection?
I don't have an objection to the extent that either the sheriff's department can accommodate it or he can make his own arrangements. I don't know where he's been testing or how they would accommodate that.
Okay. Yeah, I guess, Mr. Fragel, I would just, if you can submit a stipulation to the prosecutor, it sounds like he doesn't have an objection in principle, just that Mr. Crawford will obtain that PBT prior to 5 p.m. Okay.
Okay. Thank you.
All right. Thank you. We're on the record in People versus Pamela Bunning, file number 255029. The record should reflect the present here today. This is the date and time set for sentencing in this matter. Ms. Bunning, you had a chance to go through the pre-sentence report.
Yes.
Mr. Germerty about that.
Yes.
Mr. Germerty, are there any additions, deletions, or corrections to the report?
Judge, I reviewed the report with my client. Based on our review, there is no additions, corrections, deletions. And we're also satisfied with the scoring guidelines in this matter.
Thank you. Mr. Ziegler, have the people have any additions, deletions, or corrections?
None, Your Honor.
Any challenges to the scoring?
No, Your Honor.
Anything by way of allocution on behalf of the people?
Your Honor, I support the recommendations contained in the PSI. I think they're appropriate. It's a possession of narcotics case. Ms. Bunning has already served 110 days. I think that's a sufficient penalty at this time in terms of incarceration. I would support placing her on probation for a term of 12 months. Give her an opportunity to demonstrate that she can comport her behavior with the law. And then obviously if she cannot, there would be additional penalties. But I think that the time she served is appropriate for the crime. So I would ask the court generally to adopt the recommendations.
Thank you, Mr. Germerty, and Ms. Bunning.
Just briefly, Judge, Ms. Bunning is 40 years of age, 1 prior misdemeanor, 2 prior felonies, a limited criminal experience. There was a manslaughter, there was a prior that she was convicted for, and it is done her time. But however, with this matter, Ms. Bunning was cooperative with the officer, to the people. And that's why she received the benefit of this plea offer. I think the recommendation is appropriate and ask you to follow it, Judge. Ms. Bunning indicates that while on probation, she would continue with either outpatient or inpatient treatment based on what her probation officer recommends and will work out. So I think that's a good plan for Ms. Bunning to continue with some sobriety going forward. So I'd ask you to follow the recommendation, Judge. Thank you.
Ma'am, anything you wanted to say here today?
No, I would, if I had the choice of rehab, I would like to do outpatient so I could continue to work and do my job. And I will be fighting with my parents who are here today. I learned my lesson. Just I'm here to hopefully maintain my sobriety.
I did read through the report. I'm familiar with what happened in this case. I'm familiar with your background and circumstances also based on the information in that report. I take all of that into consideration along with what the lawyers and yourself had to say here today. Two things kind of stand out to me. Number one, your people you're associating with are, I see them, I recognize a lot of those names. I hope that you can make a break from associating with them because I'm sure you already know this, but the people that you hang around with are going to affect your quality of life in a lot of different ways. And these folks are only going to get you in more trouble, particularly when you're on probation. You can't hang around them anyway,
Right.
But aside from that, if you can find a different group, I think it would
Absolutely.
benefit you. And then I also agree that, seeking some treatment and some counseling, you've been through some things obviously in your life that I think would reasonably contribute to someone having issues with substance abuse. And the more that you can deal with those underlying things, the better you're gonna be able to deal with substance.
I do down at the jail, healing private wounds. They have grief counseling and stuff down there that I want to also, try to get into that too. Like they have great grieving counseling and substance abuse counseling, stuff like that. So.
Yeah, so I think you should try to take advantage of as many of those kind of things as you can, because I think that'll all be helpful to you. So I hope that's what you do during your time on probation. I do think the recommendation is appropriate, though. I agree with what the attorneys have said. 110 days is a sufficient sanction, and I think probation is appropriate again to monitor and hopefully provide you with some resources to get the kind of help that you need. So the court is going to adopt the recommendation and you to probation for a period of 12 months. The court is going to adopt as the conditions of the probation all the terms and conditions listed in the report. The court is going to sentence you to 110 days in the Kalkaska County Jail with credit for 110 days served. Crime victims assessment of $130. Court costs of $325, attorney fees of $350, DNA testing fee of $60, and $68 state costs, and supervision fee while you're on probation of $30 per month. You do have the ability to seek an appeal of the sentence, and we're going to provide you with some papers that explain what your appellate rights are. Mr. Murphy has acknowledged receipt of those. Right?
Yes, Your Honor, for the record, Ms. Bunning does have a copy of her paperwork as well.
Ms. Wagner, are you going to meet with Ms. Bunning before she's released?
Can she, when she gets out today, can you just direct Pam, just come over to my office, please, after you get released?
Okay.
Thank you.
Thank you, Judge.
All right, good luck to you going forward.
Thank you.